hear us, to listen us? Okay. Good morning, everybody. Good afternoon, good evening, depends where you are. My name is Mario Matus. I'm the Vice Chair of the FMG, and I'm speaking on behalf of our CEO, Xiangkun Lu, who was unable to attend today because of a last-minute commitment. As you know, the WTO is facing major challenges, particularly it is in the dispute settlement system. You know, since 2019, the appellate body has been non-functional. However, dispute settlement system through the MPIA, the Multi-Party Interim Appeal Arbitration Arrangement, which allows participating member of this MPIA to appeal panel report following procedures that mirror those of the former appellate body. Against this, let's say, terrible background, the FMG launched the WTO Dispute Decoding Series. The final goal of these cycles is to provide clear and accessible analysis of MPIA final rulings, as well as relevant panel reports. Today is our third session, and it focuses on two recent panels report. One is the DS16, and the other is DS18, both European Union imports from Indonesia. These cases, anti-dumping cases and countervailing duties. These cases raise important questions about the so-called transnational subsidies, what they are, whether they are truly a new phenomenon, how they are regulated, either under the WTO law, trade agreements, or national legislation. To tackle these questions, we have four well-known experts, but Gabriel will deal with those. This session will be moderated by Professor Gabrielle Morceau. As you know, she was appointed lecturer in the year 2000, and in 2025 became an associate professor at the Faculty of Law, University of Geneva. She teaches WTO law and supervises master thesis and doctoral dissertations. She is a visiting professor at numerous institutions promoting international economic law. She has been the president of the Society of International Economic Law and is a member of board directors of the Geneva Society for Law Legislation and is a counselor of the American Society of International Law. Professor Morceau worked at the WTO over 30 years, serving as legal advisor in international dispute, in the cabinet of the Director General Pascal Lamy, and in the Economic Research and Statistics divisions. In those days, many of us had the privilege of counting her as an advisor in different panels. For many, she was, and still is, a sort of legal guru on WTO matters. So, Gabriel, you have the floor.
Thank you, Mario. Thank you, Ambassador Matus. Thank you, Mia, the chairman of FMG. Too much time on me. We have really an outstanding set of panelists to talk about a very difficult and fundamental issue. And to start with, we have Liz Chilia, who worked for the Singapore government for over 30 years in many, many capacities. She's been panelist, I think, more than 5 times in WTO disputes, and now she works for the Singapore Business Association. Very, very strong, experienced panelist. We also have Professor Winam Zhu from Sydney University, who's the director of the China International Business and Economic Law Center. And Winam has published extensively. He's on several, I looked at his CV, several group, association, think tank. You all have their detailed CV circulated. That's why I skip. I'm so much looking forward to hearing them. We also have Professor Luca Rubini, a world expert in particular, but inter alia, on subsidies. He's professor at University of Milan, but also head of research Birmingham. Again, a long list of past experience, including sort of in disputes and subsidies. And finally, we're very lucky to have Jesse Cryer, who's probably the world expert on subsidies matter. He's now professor at Georgetown University, but he also worked for some 30 years at WTO in disputes. But before that, he worked in the private sector, and as I said, he is the world guru or one of the world guru on subsidies. The way we will function today is that we'll have two sets of exchange. Each panelist will speak 5 minutes about some of the issues. Then we'll have another round of 5 minutes comments, and then questions from participants for the last sort of 30 minutes. Unless you have objection, proposal, I suggest that I start with a few questions with Jesse, who will then introduce the topic. And allow me to throw a few very broad questions. So what is a transnational subsidy, Jesse? And is it new? Did governments provide transnational subsidies 30, 40, 20 years ago? Is it a new issue? Does the WTO talk about it? Ambassador Matos talked about CVD, that is reactions from governments who receive subsidized exports. Do they react? What exists generally on transnational subsidy? Thank you again, Jesse, for sharing your broad knowledge on this.
Okay, thanks, Gabrielle. I'm going to start my clock so I don't run over 5 minutes. Good morning to everybody. So my job here really is to sort of set the scene in the beginning of this conversation, and assuming that very few of you have read the 180 pages of dense, almost incomprehensible material that represents DS618. I didn't make it all the way through myself, but this conversation is really going to focus on this one aspect, sort of big systemic aspect, which is transnational or cross-border subsidies. You won't see those words in the WTO agreement, but this is basically the problem we're going to be talking about today. So what is this thing? What is a transnational subsidy? Sort of, obviously, there's no definition in the WTO agreement because it's sort of a concept out there, but the basic idea is a situation where you have a government in one WTO member or in one country providing a subsidy, but that subsidy is providing a benefit to an actor in some other country, right? So the sort of the big systemic question really is whether these types of measures are regulated by the WTO subsidies agreement. Now, this issue has presented itself sort of very front and center in the last few years in the specific context of countervailing measures, where an investigating authority in one country is acting against subsidized imports from another. And it's both this has been taking place both in the European Union and in the United States. So basically what happened in the EU investigation that underlines DS618 and there was actually another set of investigations in the European Union before that, is that the European Union was investigating allegedly subsidized imports from Egypt and then from Indonesia, and in those countries you had Chinese companies who had been allegedly receiving some benefits from China or Chinese public actors for their operations in Egypt and in Indonesia. And then those products that were being made in those countries were then being exported to the European Union. So the question is, can you take action against imports from Indonesia with respect to subsidies that came from China, right? So this is basically the situation in the European Union, and they've been litigating this both within the domestic courts in the EU and now in the WTO with respect to Indonesia. And, there what we had was things like loans from state-owned commercial banks, capital infusions from Chinese companies to Indonesian subsidiaries, money from the Chinese ASEAN Investment Corporation. So a variety of resources that were flowing into these Chinese companies operating in Indonesia. And that's what the panel report is about. But we've had the same thing happening in the United States. And I'll talk about this more later. But we had a set of investigations in the United States involving solar cells and modules from Southeast Asia, and Chinese companies operating in Southeast Asia, principally Chinese companies who were then exporting the products to the United States. So exactly the same type of problem. Chinese money flowing into Southeast Asia, exports from Southeast Asia to the US. Now, is this a new issue? No, it's absolutely not a new issue. We've been sort of wrestling with it for years, but it's become more prominent in recent years. I mean, I remember people coming to me when I was in the WTO asking about, if one country provides development aid for producers in another country, is that within the scope of the agreement? So, in the context of development aid, this was always sort of a live issue. Could you countervail development aid provided across borders? But it's not only in that context. It can come up wherever you have multinational corporations, complex value chains between countries. For example, imagine that a government provides a subsidy for research and development to a multinational corporation. That corporation then produces the product which is developed in 5 different countries. Is that subsidy provided for the R&D only related to the product made in the country where the subsidy is received, or does it also relate? Can it also be treated as a subsidy for the product being produced in third countries? And that actually is a very live issue. And there was a case, a WTO dispute involving washers from Korea dealing with that. Finally, and I see I'm out of time almost, but I think it's really important to emphasize that this is not just a countervail problem. This is more fundamentally a problem about what is the scope of the disciplines that the WTO has on subsidies. Does it cover this, I think, increasingly frequent type of problem, precisely because you have these complex international value chains and you have goods that may be subsidized in one country that are being incorporated into products that are then being exported from another country. And so it's an increasingly important problem, but it's not a new one. And I'll stop there.
Wonderful. I have more questions than when we started, but I'll go to Luca. Luca, you know well the EU Commission's approach to transnational subsidies, and in particular in that dispute, they used rules on state responsibility. What is that? What is the position of the EU? And how can you continue Jesse's explanation, please? Thank you.
Yeah, thank you, Gabrielle. Well, as you know, the European Commission is the trade remedy authority in the European Union, and their approach in concerning transnational subsidies, the countervailing of transnational subsidies, has really been about using the existing rules that we have in the rule book in the EU, so the EU CVD laws, which are largely based on WTO subsidy laws, for countervailing these new types of subsidies. So the laws were not changed or amended in any possible way. It was a matter of interpreting the laws that are in the rule book in the EU. And how they did that, as you have hinted at, Gabrielle, they did that by interpreting the wording by the government, subsidy financial contribution by the government, which is similarly worded in EU subsidy laws and in WTO subsidy laws, through the use of general international law, okay? And in particular, through the use of the specific rules of attribution that you can find in the draft articles of state responsibility of the International Law Commission of the UN, okay? So these are the rules that under general international law permit to attribute to one state responsibility for the wrongdoing carried out by another actor, which could be a state, okay? So it's through the use of these general principles, standards, rules of attribution in general international law, which were used to interpret the subsidy laws of the EU and subsidy laws of the WTO, where the Commission concluded that they could countervail these measures. So if you look at the regulations, the actual documents through which the EU is imposing these countervailing duties, it is clear that to them, this is not a matter of accountability under trade laws, but accountability under general international law. So you have the impression that they come to the conclusion that you cannot find an answer within the four corners of trade laws, but you need to interrogate general international law. So the whole reasoning of the regulations of the Commission is based on Article 11. Now, Article 11 permits the attribution, as I was suggesting, of the conduct of one entity to a state if that state acknowledges and adopts the conduct of the first actor. So that's the commanding legal jargon, acknowledges and adopt. Now, in the specific case of Indonesia, because there have been other investigations, the Commission concluded that this language was satisfied, but in the specific case, they concluded that the government of Indonesia had even induced the government of China to provide this financial contribution. This is also what came out in the WTO panel report. I don't know whether, Gabrielle, I have time to proceed and very quickly talk about that as well.
Yes, you have 2 minutes more. 2 minutes.
Okay, so that's a luxury. So the issue goes to the WTO, DS616, as you know, and we have a panel report in early October. Now, generally speaking, if you read the panel report, it is extremely cautious and in general, I would say, well-crafted. It immediately narrowly phrases the legal question to address to whether the specific standard of attribution used by the European Commission, which is a standard of inducement, could permit the specific countervailing of subsidies in this specific case. The analysis then is divided into two parts, very briefly here. The first part of the analysis, which takes up the large part of the report, is based on the language, on the context, the objective of WTO subsidy laws, and in particular Article 1, which provides for the definition of subsidy. And here the panel concludes that what we have is an exhaustive list of entities, an exhaustive list of forms of financial contribution. In other words, if it's not there, you cannot, on the basis of Article 1 on its own, of WTO subsidy laws on their own, to cover transnational subsidies. Then in the final part, the coda of the report, which is the shortest part, they do focus on the specific legal test used by the European Commission about whether, via the use of Article 11 of the International Law Commission drafts on state responsibility, you could nevertheless interpret by the government language in order to include the specific case of inducement that you had before the European Commission. And here the conclusion, no, you can't. So the conclusion in the end is that this regulation of the European Commission is not in line with WTO subsidy laws, and hence the EU is losing this specific case. I will stop here. Perhaps we will have time to go back and comment a little bit on this report.
Thank you very much, Luca. Yes, later on, comment on whether other doors are still open for that sort of transnational subsidy. Now, Winam, you've published extensively, another world expert on the topic. What is your perspective on this panel report, and in particular on the issue of whether rules today of the WTO cover transnational subsidy? Are there different types of transnational subsidies, etc.? Thank you.
Thanks, Gabriel. I'm obviously the least experienced in this panel, so thanks for having me in this panel. So I'll just continue on what Luca has just introduced the panel report and also the is EU Commission's approach based on state-to-state attribution. And what the panel said was a very specific rejection of the approach adopted by the EU Commission in that particular case, which is to say that if a conduct of one government is induced by another government, and therefore that will be sufficient evidence for attribution between the two states. And the panel rejected that on the basis that of the WTO subsidy agreement itself. And the WTO subsidy agreement provides only a closed list of conducts where you can actually attribute the acts of or conducts of one entity to a government. And the panel did use the specific example under the subsidy agreement where you can attribute the private entities act to the government based on entrustment and direction. But the panel also says that there is no other clear language for other conducts to be considered under the subsidy agreement itself to as evidence for attribution between states. What the panel did not say at the end of this dispute is that the panel did not exclude the possibility that there might be other conducts other than inducement that might be sufficient to allow state-to-state attribution. And the panel also did not say that did not close the possibility that the subsidy agreement may be applied to subsidies granted by governments outside their territories. So I think that perhaps goes to the question about the US current approach, which we can come back in the second round. And the second point I want to make is that I think WTO members are actually divided in this dispute, which is quite interesting. There were about 12 third-party submissions out of 17 third-party participants in this dispute. And you can see that most of the submissions disagreed with the EU's approach, including countries like Thailand, Egypt, Argentina. And only the US is perhaps the major supporter of the US approach. And you can see the divides not only because of the countries that may not actually use subsidies to countervail or to use countervailing duties against transnational subsidies, but I think this goes back to the point of Jesse's that most of the countries that actually receiving investments may have that problem of transnational subsidies sitting in the supply chains and therefore might be potential targets by countervailing duties. Do I still have time?
No,
Okay, I'll stop there. We can come back to you.
We come back. Yeah.
Yes.
This is so interesting. Thank you, Unam. Now, Liz. Liz, when we prepare this, had an interesting perspective on this whole issue. And I'd like you, Liz, to share that with us. You argued, for instance, should we deal with this issue in the WTO? In FTAs, you told us that it's handled a bit differently. So what would you add to this sort of primary description of the issues? Liz? Are you there?
I think you muted, yeah.
Yes, I muted
Liz,
myself
you're
just now.
muted,
I've unmuted it now. So thank you very much for welcoming into the FMG, and so pleased to be on this, my first panel. So as Gabriel says, I'm looking at it more from a policy lens because I thought I have such great legal experts who are speaking before me who will dissect the case. So what then is the implication of an outdated rule at the WTO, because this is the whole issue of the causal link. So at the WTO, to address imperfections in causal link, they've come up with the fish subsidies. But can the WTO then come up with something now which is on state-to-state, transnational? Are they able to do so, especially as Ambassador Mario has already said, in the current paralysis of the WTO? Are you going to amend anything to cater to this? So that's why I thought I'll look at a policy call. many, especially the US and the EU, have already started to look at this from an competition element. So subsidies given to state-owned enterprises who are then providing FDI into third countries and therefore undermining the market situation. How are they to be addressed? How would you look into this issue? So you have a whole list of prohibited or cautionary behavior by state-owned enterprises because they look at it from the lens of anti-competitive behavior. This is going to grow in importance because you have seen there was some reference to the Belt and Road Initiative, and therefore to me, it is not so much a surprise that my fellow ASEAN members, when they participated in this panel, were very cautious because they still need the FDI into their country. They are not going to say that, okay, China, you can come in, but then you have to behave in a different way, because at the moment that will then fall under how you look at investment, and then so basically the whole issue of how you look at a level playing field is a whole new policy call today because of aggressive supply chains, aggressive FDI coming in from new players like China. You never know, might be India next, who may not always be following the rules that we are used to. So I thought then that I will also bring up the fact as to why then did the EU decide to appeal this case. The EU does not have a track record of appealing into the void. In fact, they've also got a case with Indonesia, which they did not appeal, and now Indonesia is taking them to task about failure to implement. So why this particular case? Why in this particular case are they citing the fact that Indonesia is not a member of an MPIA, and therefore they have no choice but to appeal into the void? Are they trying to get Indonesia to be part of the MPIA, or food for thought, are they buying time? What time are they trying to buy? So I thought I'll just raise the fact that the EU has just, recently over the last 2 years, adopted new regulations, foreign subsidies regulations, rules to ensure fair and open EU markets that entered into force in January 2023. And this regulation has a very unique perspective because they do take into account the positive elements of having the FDI versus the negative elements of what this FDI could do in the third country for the exact same situation that we are doing today. So I was talking to Gabrielle to say that maybe they have appealed to buy time to see how their SR is working out, give them more chance to then negotiate with Indonesia or to see how to settle the case or how they want to bring it up, because they have tabled subsidies reform at the WTO for quite some time now, but nobody has actually engaged in these discussions. The other policy factor that I wanted to raise was the fact that EU and Indonesia have just concluded their bilateral FTA. Did that then have a further impact as to why the EU appealed this case? Because it's from all the earlier presentations, it is getting clearer that the 1995 WTO agreement on subsidies and countervailing measures does not meet current ways in which transnational business is operating. I don't know whether I have more time, but I thought I'll leave all this food of thought for you all to think about.
Yes. I had told you all that it was an outstanding panel. The amount of issues we've reviewed or open is fantastic. So we'll go back to Jesse. And Jesse, you've heard all that. If possible, I'd like you to do two things. Explain the more specific situation of the US regulation and position, and comment and respond to any of what you've heard before. Thank you, Jesse.
Okay, so I guess the first thing to say is, your average listener might, assume that this panel actually gave us some clarity as to whether transnational subsidies are or are not within the scope of the ASCM. And the answer is it absolutely does not tell us anything. It explicitly tells us we don't know. They really focused on the particular approach that the European Union took. And the European Union took that approach because their own basic regulation is much clearer than the WTO agreement. And their own basic regulation says that the government providing the subsidy has to be the government of the country of origin of the product. But the WTO agreement doesn't say that as clearly, right? So we have no idea whether the ASCM agreement actually covers transnational subsidies or not. We only know that the European Union's way to get around its own basic regulation doesn't fly. Now, the Americans actually wrote their statute in a way which unusually actually tracks the WTO agreement more closely than the EU basic regulation does. So there's nothing in the US law that would prevent the countervailing, or arguably that would prevent the countervailing of transnational subsidies. The US had a practice of not countervailing transnational subsidies, and they put that into a regulation, but it's not clear that the law requires it. So a couple of years ago, the US got rid of its regulation prohibiting the countervailing of transnational subsidies, and the Commerce Department's position is that the statute permits them to do it. And so they've done this bunch of cases. And this bunch of cases, as I say, basically, Chinese companies moved to Southeast Asia, and when they moved to Southeast Asia, they started receiving all these, inputs from China. And they got financing from Chinese banks and things like that. So the question is whether these Chinese companies operating in Southeast Asia are receiving transnational subsidies. And the Commerce Department found that yes, they were, and they countervailed them. And those decisions about countervailing those transnational subsidies and the very legality of doing so in the United States is now before the Court of International Trade. So in the United States, they didn't have to do all this sort of international law commission, attribution, all this weird stuff that was really about avoiding the language of the basic regulation. They went right to it, like the United States tends to do, and it says we can countervail transnational subsidies, and we're going to. And that is now being litigated in the courts. And the dispute settlement up till now gives us no answer to the question. If you look at Article 1, it says there's a financial contribution by a government or any public body within the territory of a member, but it doesn't say within the territory of the member from which the product originates. Now, there is some other language, some other contextual language particularly in Article 2 regarding specificity, which talks about a subsidy being specific within the jurisdiction of the granting authority, which, could provide some guidance about what Article 1 means. But that's all remains to be fought out. And so basically, the unfortunate conclusion to a certain extent of this discussion is that because of the particular way in which the EU had to tackle this problem, and because the panel was being extremely cautious about what it would say, it doesn't rule on whether transnational subsidies are within the scope of the subsidies agreement. It doesn't even provide much of a ruling about attribution, but only about a very particular type of attribution. It tells us, by the way, also nothing about whether the International Law Commission articles are or are not customary rules of public international law, or very little about what they mean. It is interesting to observe, and this is, I think, notable, that this panel really decided to focus on the text of the WTO agreement. And they basically said, articles, schmarticles, we don't really care about the articles, We're not going to look at public international law. We are going to focus on the text of the WTO agreement, of the SCM agreement, which is notable because the last time we had a big issue like this, sort of a similar type of issue, which is the famous public body issue, the appellate body very much focused on these articles as sort of the source of their decision making, and there was a lot of criticism. So it's a very interesting approach with a panel of very distinguished panelists, including a former appellate body member, taking a very narrow, very cautious approach that basically leaves this core question we're talking about today completely unanswered.
Thank you, Jesse. So when you repeat, and that's a bit what Luca was saying, this panel, and that's my question to Luca, next speaker, only said that inducement, as argued by EU, is not possible under SCM as a basis for countervailing duty, but nothing else. Luca, can you correct me and explain what the panel said, in your view, and the EU interpretation in particular, going to what you started, going outside the WTO to explain its actions?
Absolutely. I mean, I do agree with what was said by Jesse. I mean, if you read this report, don't expect that by the end you will have the answer, because it is obvious that through reading it, that the panelists were at pain not to say anything more than it was necessary to sort out to solve the dispute, which is fine. So whereas the first part, where they analyze head on the issue, the specific issue of the inducement test of the Commission under the language of WTO law, as I said, is very clear, it's very orthodox, and the conclusion is under no way we can find this type of cross-border subsidization within the four corners of Article 1 of the Agreement on Subsidies. The part that is more ambiguous is the final part, where they do seem to assume, to accept, and again, it's not clear what is the specific use they make of Article 11, so these rules of attribution under international law. But I think it's a fair conclusion to say that they did accept the possibility of analyzing the question again in the future under Article 11 of these draft articles of state responsibility, and then they say that verbatim, explicitly, they did not exclude that under other circumstances they might have reached a different conclusion. So clearly the door is closed this time, but the door is also left open. How much open is not clear. And so it's left to future litigation. That's why I'm also a little bit surprised by the appeal by the EU, which is perhaps the only case where the EU has appealed this, because yes, they lost in this specific case. But if you look at this opening at the end, you might, if you are the EU, you might be thinking, okay, but in other cases with other different types of tests, which are closer to the language of Article 11, perhaps we could sneak through and our countervail of transnational subsidies could be accepted under WTO law.
Thank you. Winam, I cut you short on your first presentation, so you can go on. And so what is the future of transnational subsidies then?
Thanks, Gabriel. I think I'm just going to continue on what Lucas left over there. The possibility to apply or consider Article 11 of the ILC articles in future disputes. My observation on this is that if the EU continues the state-to-state attribution methodology, the chance is very, very small for the argument to succeed in the WTO disputes. The reason is because the ILC articles, Article 55, specifically says that if there is that special rules under other international treaties, then those more special rules should prevail, which actually supported the panel's approach and the party body's approach that they only use the ILC articles, including Article 11, as assistance. But that assistance can't trump what the subsidy agreement itself says. So if you think about what the panel said in this case, is that the subsidy agreement itself does not provide or explicitly set out other types of conducts that can actually attribute between states, and contrast that with how you can attribute the private entities' conduct to the states. And therefore, I don't see how there is any room to expand the circumstances or the conducts beyond inducement that could be covered under the subsidy agreement itself. So that's one point I want to make. And the second point, I do see the flexibility, which is actually the US approach, based on the interpretation of by a government or by a country, by saying that if any subsidy provided by a country, that does not have to be the exporting country, if the subsidized imports come into the United States, that will be potential subject to countervailing duties. So therefore, I think the US approach completely avoided the question of state-to-state attribution, but based on the ambiguity that the panel left there, which is about by a government or by a country. So I think that's the second point I want to make. Now, final point, even if one wants to apply Article 11 of the ILC articles, the language adopts an acknowledgement of very, very strict conditions. Based on, if you read the cases included in the ILC articles, there was a list of cases where Article 11 was applied previously, was very, very strict. It does not include inducement, it does not include approval, it does not include benefits from subsidies or any conduct from another government. It requires adopts the action or the conduct as its own. So it's a very, very strict, high threshold. I'll just stop there.
Well, I have a question immediately to you because I heard you talked about the implications of the US or EU approach. If this was continued, implications as a reaction by EU, who could do the same, and it could also hurt, of course, EU-US. Can you say something about how China may react also? And in the next round, we'll talk about how to deal with the issue if today's rule cannot. But in terms of boomerang effect.
Yeah, I think if the state-to-state attribution approach is taken as a standard approach to attribute the responsibilities between states, that opens the whole Pandora box, the floodgates. So if you think about as an example, the Inflation Reduction Act subsidies, the US provides subsidies to its FTA partners based on local content requirements, and also about where those vehicles needs to be assembled, where the critical minerals should come from. Can you attribute the subsidies provided by the US government to the FTA partners, which benefits from these subsidies? So that's one example. A more recent example, the rise of critical mineral arrangements. So the most recent one is the US and Australia, so both parties commit to provide 1 billion financing to projects in each jurisdiction. And just reported last week, they committed $5 billion provided by their respective policy banks. Can you attribute those subsidies provided by one party to the other party? So I think those are the broader questions.
These
I
are
think
good example of attribution, but later on I'd like to hear you. If the world follows the US approach, is it better?
I think the US approach is still limited to the subsidy agreement itself, because that's basically based on the interpretation of by a government or by a country. But state-to-state attribution might actually extend beyond subsidy itself. So again, another example, if you think about the US bilateral deals with Malaysia, with Cambodia, requiring the other states to take certain actions, security-based actions and other actions, restrictive actions, can you attribute those actions, assuming that in violation of WTO rules, so that's a wrongful act, can you attribute the wrongful act of the other countries to the United States? So those kind of broader questions I think we need to be thinking about.
Thank you very much in attribution. Liz, before we go to participants if they have questions, so what do you comment on these, both the EU and the different US approach? What's your view after 30 years of practice in international trade?
So I think to me is the whole issue in this case seems to be about attribution and inducement. But what happens if there was no clear attribution or inducement, because you are attracting FDI all the time? A Chinese SOE comes to, or even a Chinese business comes into Singapore, let's say BYD, the EV company is here now, they are cornering the market and they are providing it difficult for other car manufacturers to sell their goods. It could be a BMW, Ford or whatever, but because the Chinese are conquering it because they are able to underprice the good. So this was not because the Singapore government asked, BYD to come and induce their investment. No, they came on their own. They are doing it according to what they deem to be market practice. So this brings us back to, are you practicing as a market economy? Are you practicing on commercial terms? How much of a loss can you bear because your losses are being underwritten by your home government, but you're operating in a third country? So that's why I say that the current context of the subsidies and countervailing measures agreement, which looked at the good moving itself rather than the impact of operating in a third country with home country benefits, is not something which the SEM, I think, fathom. I think the US has been cognizant about how they need to look at this at a broader, and that is why even when we did our first bilateral FTA with the US 21 years ago, we have an SOE chapter, because the US was already very cognizant about the fact that state-owned enterprises get unfair benefits in their view, even if it's a simple thing as better loan rates, better repayment rates, because you are trying to get expansion from this SOE. And then after some time, it becomes a blurred aspect between whether it's the state directing it or whether it's that entity itself as they expand into third countries that is causing this problem. And when you're expanding into the third country, are you just supplying the good for that domestic market? No. Today, because of the supply chain, because businesses are all looking at cost-effective production, if you're going to get somebody that's going to sell you cheaper steel, for example, good quality steel, but cheaper, you're going to use it for your product, maybe a gaming chair that's going to be sent to the United States. So how do you look at this? How do you say that it is being undermined? Is it being undercut? And so that's why I think that the WTO is stuck, because it's stuck on a very old-fashioned way of looking at associating the undercutting to the good or the specific service that's coming one cross-border. But actually now we're talking about two cross-border impact. So it's a pity that the WTO didn't agree to have competition rules, that they rejected that Singapore issue, because that could have been something that could have been taken into account to try to deal with this new way of anti-competitive behavior, non-market forces behavior. And that is why I was saying earlier on in the FTAs, that's how. So the US-Singapore FTA, and even before the US pulled out of CPTPP, you have very thorough provisions under competition and under state-owned enterprise. What is the impact on anti-competitive, unleveling the playing field, and what sort of action can you take? And so I was looking at the EU's FSR, and I think they are closer a bit more, not entirely how the US approached it, because they are also cognizant about how countries, especially developing countries, are attracting FDI. And you don't want the developing country to say, oh, I cannot because I need to look at the negative or the positive. So the EU's FSR, I like this part, if I may just quote about it. It looks into power to investigate financial contributions granted by non-EU countries to companies engaging in an economic activity in the EU and redress, if needed, their distortive effects. So to me, this is a new way. Can this new way then become a WTO rule? I don't think in this current climate we are going to be able to amend the SEM. I mean, even before Trump 1, before Trump 2, the EU, to be fair, has been tabling proposals at the WTO, but nobody's been paying attention to trade remedy reform. So what do we do? But having said that, it might still be easier to try and do some sort of plurilateral reform, some sort of engagement. The OECD is already starting to talk a lot about this, and to see then how do you take it into the WTO, because that might be easier than saying we want to bring back competition, because it's a Singapore issue that died. I can just hear my fellow developing countries say, no, it's a no issue anymore. So how do you do the SCM? Or if the WTO really cannot do anything today, which seems to be the case, plurilateral outside, look at the major FTAs, the regional FTAs that are looking into some sort of controlled, in a way, transnational impact of subsidies given. Primarily at the moment, we're talking a lot about China because they are the most visible. But if you go out of industrial goods into agriculture, you have a lot of all of this that's taking place as well. So that will be my food for thought for us to see how we're going to take it forward beyond just the narrow confines of a dispute, but for the larger WTO rules itself.
Thank you. Thank you very much. Very, very rich exchange and outstanding respect of time. We have 40 minutes to take questions. I see a questions from Ignacio and another question from a non-member, Monsieur Comment. I see again Hero. I don't know how Ambassador Matus wants to proceed. Mario, do you take the questions or you let me take the questions?
No, you are the moderator. You have the floor entirely.
Ah, okay.
You are the boss.
Doesn't happen often. So I'm sure that Jesse has additional comments, but I suggest we take a few questions and then you will all have time to comment and you can interject additional points, additional to the specific questions. So I suggest Ignacio and then Hiro, and then if there are no members, I'll read out the question of Monsieur Comment. Ignacio.
No, thanks a lot, Gabriel, and it's really a fascinating panel. I mean, my sense from hearing the discussion is that the US approach is a more straightforward one, both from a legal and from a policy point of view. I would be interested perhaps in Jesse saying a little bit more about how solid he thinks it would be in case there was going to be a dispute in the WTO about the interpretation of the ASCM. I am personally of the view that the rules of state responsibility are really a blind alley and they are not really going to be taking this discussion anywhere. And what I'm a little bit surprised is why the European Union still insisted in this legal defense in the case vis-a-vis Indonesia. Why didn't try to argue on the basis of the rules of the WTO as such? I don't know whether Luca has any point of view on this. I think it's perfectly, in my view, possible to argue before the ECJ on the basis of rules of state responsibility, where they might actually receive a better reception than they would ever do under the WTO panel. So I'm a bit surprised that the European Union did not decide to argue more on the basis of the text of the ASCM. I'm not surprised by the way that the European Union chose to appeal. I think this needs to be understood in the context of the broader relationship with Indonesia. Indonesia appealed into the void the dispute about export restrictions on nickel. So I think probably the European Union further that was a broader issue in terms of that relationship with Indonesia, why they decided to appeal. In any case, they were not fully satisfied with the ruling of the panel. Finally, just one comment. I don't think that the FSR would be a solution for the type of issues here because the FSR only applies to subsidies which are provided to enterprises which are established in the European Union which are doing business in the European Union. So it could not be used to try to tackle the transnational subsidies. So yeah, but my question will really go to Jesse and maybe Luca.
Yes. I'll take another question from Hero, and we have 3 questions from the floor, and then I will ask each of the speakers, starting with Jesse, to respond and comment. But Hiromi Yano, please welcome to FMG, and please your question. Hiro is also trade remedy and subsidies expert.
Well, thank you very much, Gabriel. Thank you very much, everybody. I just, first of all, wanted to say hello to everybody. Thank you very much for having me. It's my honor to be listening to you guys and coordinating. And then, mindful of the time, I wanted to make 2 short comments. One is, I think Liz and some others mentioned this, but what is the relationship with the WTO reform and this specific issue of transnational subsidies, right? As Jesse mentioned, this is one of the biggest things which the members are talking about. And then again, without going too far into legal nitty-gritty, is as Jesse and others all know, I think if we, the FMG, had the authority to rewrite the subsidies agreement, which we don't obviously, but assume we do, right? And then I think the easiest way, in my view, and Jesse, you could maybe correct me if I'm wrong, but I think the easiest way to deal with the so-called transnational subsidies is to take a look and revise Article 1.1A1. And then it says, of course, as you know, the definition of subsidy, right? And then the subsidy, it shall be deemed to exist if there's a financial contribution to the government or any public body within the territory of a member. And that's why all the dispute complaining parties and defense parties, they do try to get away with this thing by using this attribution language and all these things, right? So my point is, legally, in my view, it's not that this the transnational subsidy is completely outside of the WTO rules, but it's relatively a technical issue. And I think the reason, I don't know the drafting history, and Gabriel, you know, and Jesse, you guys probably know this better than me, but I think the reason why the drafters of the GATT did not, or the WTO subsidies agreement wanted to talk about within the territory of the members, I think they thought this was common sense, right? Why would you like to use your taxpayers' money in order to subsidize companies which may be related to your kind of capital has a financial relations with your let's say Chinese or Japanese or whatever? Why should you subsidize foreign companies? But that's, I think, one of the it's a Chinese I think way of thinking about industrial policy. So I think my point one is, thinking about WTO reform is as usual, not as usual. I think this is legally a relatively easy one, but politically a huge one. You could never ever change this subsidy agreement in the WTO, I'm sure, right? And my second point is, sorry, I'm coming from outer space, and this is a really out of the box issue. But I agree with everybody that this trying to address this issue through this lens of attribution and the ILC draft provision is a little bit awkward. I surely understand this. But my, let's say, legal philosophical, let's say, thinking is, if the members had only two choices, right? One is to really try to expand the interpretation of the subsidies agreement and try to deal with new issue through an interpretive, expansive interpretation of the WTO rules. Or if the only other choice was to discuss forever, right? Talk about negotiation forever. Which would we prefer? And then me personally, I know you guys are all good lawyers, and you will probably scold me, but if the world had only these choices, I thought maybe dealing with the first one, trying to have an expansionary interpretation, and trying to deal with this issue arguably within WTO rules, rather than completely abandon WTO. Say, you know what, this is completely useless. Just go outside. Yeah, thank you very much. This is my out of the box comment.
Thank you, Hiro, for your comment and question. Now I suggest I'll read out 3 questions from the floor, and then I'll go to, in the order, Jesse, Luca, Winam, and Liz. So the last question, do you think developing countries are more vulnerable to distortions caused by transnational subsidies, while at the same time being less institutionally equipped to investigate and respond? Other question, to what extent can the EU foreign subsidies regulation be seen as complementing rather than bypassing the WTO subsidy framework? And where do you see the strongest argument for and against its WTO compatibility? Very broad question. And the last one, interesting also, is with regard to Article 10 and 32 of the SCM, countervailing duties may only be imposed in accordance with the subsidies agreement and GATT. How then did the US address this exclusive rule? Because SCM is lex specialis. More specifically, don't you think, and this was a bit addressed to Luca, but to anyone, that it would be more consistent with WTO law to have recourse to a non-violation complaint, arguing that Chinese subsidies in Egypt or Indonesia nullify or impair the general level of concession. I find it difficult to see non-violation since there's a provision, the SCM, but please, 3 excellent additional questions. And then I go to Jesse. You respond to what you want, you comment to what you want. You have a big 5 minutes.
Okay. So, I mean, Ignacio's question, of course, is the big question. Basically, this whole thing up till now and these disputes and the EU's approach is all sort of dancing around the core question as to, what the SCM agreement does or does not cover. And my personal view, and there are all kinds of articles and all kinds of debate, my personal view is that Article 1 is profoundly ambiguous. It says there's a financial contribution by a government or any public body within the territory of a member. Indonesia is a member, China is a member. So the question is, does it mean a financial contribution within the territory of the member, which is, in the case of countervail, exporting a product, or within the territory of the member from which the product originates? And we simply don't know. The European problem was that their basic regulation was more explicit on that point, which is why they had to come up with these crazy, excuse me for saying it that way, this attribution stuff to get around the problem of their own basic regulation. I think Article 1 is profoundly ambiguous, but there is contextual language in Article 2 where it talks about a subsidy that has to be specific to an enterprise or industry within the jurisdiction of the granting authority. So how is a subsidy provided by China in Indonesia somehow specific within the jurisdiction of the granting authority, which is China? Now, I don't think that language was put there to deal with the problem of transnational subsidies. It was really to deal with these issues that, provincial governments, subnational governments in Canada and all kinds of stuff. But it is contextual language, which is really hard to deal with if you were dealing with a transnational subsidy. And I'll tell you how this has worked out in the United States. They said transnational subsidies can be countervailed. And of course, they're looking at their own law. They're not focusing on WTO law in the US. But when they got to the specificity discussion, US law mirrors Article 2 of the subsidies agreement. So they had to say, well, how is this subsidy specific? How these subsidies provided by China within in this particular case, Vietnam, when they had to say that these Chinese companies operating in Vietnam they have this relationship with the Chinese government, and therefore they are within the jurisdiction of China, even though they're physically located and operating in Vietnam, which is really very awkward. And that is also up on appeal. So the first question is, how clear is the agreement that transnational subsidies are or are not within the scope? Article 1 is profoundly ambiguous, and I think you could, argue in dubio mitius and, sort of give the country the sort of the benefit of the doubt. But Article 2 is trickier, right? So as a contextual argument, it's not so clear. Non-violation, there are people who love to talk about non-violation, It's basically sort of useless, frankly. We have, non-violation complaints is basically saying, well, you guys are really screwed, but don't worry, theoretically you could do something, but it's not ever really going to happen. And I do think this discussion about the foreign subsidies regulation is really quite relevant, not because it would deal with the countervail problem, because it really is designed to deal with a completely different problem. But whatever the ruling is going to be about whether transnational subsidies are subsidies within the meaning of the SCM, if you have measures that are designed to deal with subsidies within the definition of the subsidies agreement, then you have a problem with Article 32.1, which says you can't take any specific action against subsidies other than that which is provided for in the subsidies agreement. So a ruling about transnational subsidies could also have relevance to I know there'll be a lot of arguments about this, but it could also have relevance to the legitimacy, WTO legitimacy of the foreign subsidies regulation itself. And I'd just like to sort of emphasize at the end, I do think this is a huge systemic issue because, if you have a rule that says I can provide, say, let's take the Airbus example, even though, the EU is a member, but Germany provides a large subsidy to manufacture a fuselage of an aircraft. The fuselage of the aircraft is exported to Toulouse, and they make an airplane, and the airplane is exported. If transnational subsidies are not within the scope, and if the EU weren't an independent member, then there would be no way to address that subsidy. And where you have a situation where you have subsidized products moving to other countries and generating final products, and in that context, you would basically have a set of rules that say, that any subsidized product in the supply chain, once it moves out of its country, is simply not, the subsidy is not subject to any disciplines at all. And that is I think, a major systemic issue to think about. So I'll stop there.
Thank you. Luca, do you want to comment? There's lots of questions in the Q&A for the speakers if you want to look at them. I'll try to take them afterwards, but please, Luca.
Yeah. Well, I've been writing a lot here. You can see a lot of comments and a lot of follow-up. First thing I would like to say, clearly we are in a scenario which is really a new wine in old bottle scenario, because we are talking about really a new type of measure, or new type in the sense that it has become really salient, as was Jesse was saying at the very beginning. And how do we square with what we have? There was a point made by Hiromi, and I think it was pretty interesting, when he suggests that if you go back to the negotiating history, even if you don't look at the detail, it is highly unlikely, it's common sense, that they could not have been thinking in the 1980s about this type of scenarios. This might mean that, I don't think there is any evidence there that they did discuss about that and they did want to cover that. It's highly unlikely. So in my view, you should adopt a kind of cautious approach, very much as like the panel adopted. I will go back to this point. In any event, I think it's quite interesting to see that there is quite a large agreement that the use of state-to-state attribution is not the way to go. And I do agree with what was said, that if you start using that, the rules of the ILC, it's like opening Pandora's box, because it is really becoming, you never stop. And also, if you want to be more technical, I do believe that the ACM agreement already provides for specific rules of attributions. And these rules were specifically negotiated in the 1980s and 90s. And you cannot get away with that and now use other general rules of attribution to enlarge the scope of the rules. Although clearly the rules, perhaps, they are not ideal now. So what should we be doing? Reinterpret the rules. As Jesse was suggesting, there might be some scope for an expansive interpretation, but we also have other indications that this is not possible. We don't necessarily need to redraft the rules. There is something which we didn't mention, perhaps it's the elephant in the room, and perhaps politically this is not viable, but this would be the authoritative interpretation under the WTO agreement, Article 9, paragraph 2. So it's for the members to come out with an authoritative official interpretation. That is how we want to interpret the rules now. Clearly, this is not politically viable. So we are really left now with these few members, the US and the EU for now, countervailing these measures, but nobody really knows whether in the future they will be the subject of countervailing actions, because my understanding now, as also some examples pointed out by Wei Huan beforehand, is that other countries are starting to invest across the border, not only China. So what will happen? So I leave it here with this question.
Thank you. Please, Winam, do you want to respond to any of those questions?
Yes, Gabriel. So I do want to just take on one specific question that Jesse also commented on, which is the non-violation claims as an option, alternative option. I know, every time that we talk about non-violation claims, one can be very, very pessimistic about the opportunities of winning a non-violation claims. But I do think that if now we're facing new issues and the WTO agreement is an incomplete agreement, has many loopholes, it is better than creating new interpretative approaches that perhaps was not intended to be covered in the WTO law, by looking at what we're actually trying to deal with. So what we're trying to deal with here is actually the effects of subsidies. And if that is the purpose, then why not leaving the developing country, which is the host country, which needs capital, foreign technology, for its own industry development, leaving the developing country alone in the process, right? And deal with the subsidizing government directly. And the way to deal with the subsidizing government directly is by non-violation claims. And I do see there are actually flexibilities that one may actually advance a non-violation claim. So if you look at Article 26(1) of the DSU, which does not only talk about nullifying and impairing the benefits, but it also says about attainment of any objective of that agreement. So one can make an argument that because of the new way that one country or other countries providing subsidies across the border, that not impairs or impedes the achievement of the objective of the subsidy agreement, which basically provides the opportunity for an importing country to use countervailing duties to level the playing field to counteract the effects of harmful subsidies. So I think there are actually room to make an argument under non-violation claims. We know that non-violation claim provisions was created in 1940s, right? And a group of cases since then. But when at European rounds, the DSU was introduced, the legal conditions introduced by GATT panels were deliberately left out in Article 26(1) of the DSU. So which, for me, leaving some room, at least for some flexible interpretation. The benefits of doing that is to say that now, if China, for example, then let's negotiate because your subsidy impeded the achievement of the subsidy agreement, does not allow us to adopt countervailing duties to counteract the effects of the subsidies. So that end up with a negotiation between the subsidizing government and the importing government, and leaving the developing countries still using the subsidies potentially, but for those governments to negotiate a mutually agreed solution.
Very interesting, Wenam. Thank you. Liz, do you want to comment on anything?
I thought I would just take a stab at the developing countries, whether they are more vulnerable. And I'll say it depends on the sector, and it depends on what sort of anti-competitive behavior in the third market that they are trying to export to, that they may be facing this problem. But by and large, developing countries, as Wei-An has already noted, we are attracting FDI because that's the way that we are improving our industrial and economic development. So they won't be more vulnerable in that way. But what are the conditions then of investment? So maybe another approach, I was just thinking as all my fellow panelists were talking, is that because I've done FTA negotiations ad nauseum, and for FTA benefits, you look at the originating good. You don't go so far behind. So even though the subsidy is not given within Indonesia, it's given by China, but it's a Chinese entity that's now an Indonesian company. Can you not then say that that Indonesian company is operating within the territory because they have got subsidies? You don't really need to trace so far back because you're looking at the originating good. Would this then perhaps be a way to try and relook at this state attribution? Because what is the difference then if it's an Indonesian company that's referred, and I take the cue from Jesse, development aid in the past, or getting better bank finance from the IMF or the World Bank or something like that, that allows it to compete? So is that possibly a way that we might be able to look at this without having to reinterpret the SCM agreement? Because it's going to be really hard whether to do Hero's interpretive note or authoritative interpretation unless there's another dispute and where these issues are really raised up as part of the consideration to the panel, such that the panel can speak on it, and then that can become part of the literature for us to refer to for subsequent panels, or even if WTO reform finally takes off, that we can look into it as persuasive practice to take into account. But the main thing is that what is the market distortion that's taking place that we want to address? It's not just transnational subsidies per se, but what is the distortion that we are trying to protect?
Thank you. Thank you, Liz. This reminds me of the OECD principle of competitive neutrality, which to me also implies let's not focus only on who gives the subsidy, but the distortion. We have 13 minutes. I want to read quickly some of the questions and give to each panelist another 2-3 minutes. So there was a question from Carlo Di Stefano, which was in part responded to Jesse and Luca, about whether Article 1.1A1 of SCM is lex specialis, and whether really EU lost because the panel concluded that those rules are outside the WTO and the SCM is self-sufficient. Now, another question from Christina Agrotu. Do you think, did the panel criticize the imposition of specific rules of attribution? The answer is they didn't criticize, they said they were not relevant. And did they not go out of their way to interpret another treaty's jurisdiction? And then the question came from Antoine, which we already asked. Maxim Smelev is the US DOC has implemented CVD measure on explosive from Korea. That's a specific dispute and investigation that included Chinese input for less than adequate remuneration. So the issue is now being discussed in a CVD investigation against Turkey with regard to, again, aluminium from Russia. So the choice of supplier, he writes, for another input can lead to a CVD being applied. I'm not too sure what the question is or whether it's a comment. And the last one from Melinda, I think, is what's the response from China to all that? Politically speaking, after the dispute, did they engage? Are they willing to discuss new rules for modern subsidies? And finally, I thought I saw a question from Lothar. Yeah, again to Jesse. Did the claim justify a narrow focus only on the EU justification, or is it a broader sort of approach? That is it a breach as soon as the CVD member has not properly explained the specific subsidy, or is it a breach only if there's no specific subsidy? So we have 10 minutes, 4 panelists, 2 minutes, 30 seconds each. Please, Jesse.
Okay, so we can talk about the relationship of the ILC articles to to WTO law. Only the public international lawyers in the group could care less, probably. But I do find the whole discussion about sort of lex specialis interesting. What I find interesting is that if you look at the big public body ruling, DS616, although the appellate body never sort of explicitly, they discussed in agonizing detail the International Law Commission articles when interpreting Article 1, even though they never sort of strictly speaking, applied them. And it was, I think, very clear to everybody that they were basically following the International Law Commission's approach. And they were really bringing public international law into the interpretation of the SCM agreements, and arguments about Article 55 and lex specialis, and we should look at the SCM agreement and not at public international law, were basically swept aside. And this panel took a completely different approach. And they basically said, what we care about is the WTO agreement. They never explicitly said, the ILC articles are irrelevant or whatever. But effectively, they said what we care about is the text of the SCM agreement, and we really don't care very much about the ILC articles because we have a set of we're going to find the answer in our treaty text, which as a WTO lawyer I find personally sort of satisfying. Let's look at the treaty and see what the treaty says. And so I found that was sort of a strikingly different approach, particularly given the composition of the panel. So we have Max's sort of question.
30 seconds, Jesse.
30 seconds. Okay. These U.S. cases precisely involve inputs coming from China and getting incorporated in exports from third countries. And that's precisely the question. Is that going to be within the scope of the SCM agreement or not? If it's not, that means that you basically subsidies get washed away when an input moves to another place, which is a very interesting policy question. I'll stop there.
Thank you. Luca?
Yes, quickly on the ILS, on the draft articles, the point that was already addressed by Jesse, but just a couple of extra points. Answering the question, is it lex specialis? I think so, for the reasons that I mentioned beforehand, because the treaty, the WTO agreement on subsidies is already regulating in quite a detail scenarios where you have a government directly, a public body, a private body. So there are various scenarios which were considered already by the negotiators when you have another entity that is giving the financial contribution. So it's already there. We already have specific rules of attribution, and we know historically how difficult it was to negotiate these rules. The reason itself for why we have this conversation is because these rules are very important, they are very controversial, they're very topical. So I would pay particular attention using a tool which is external to WTO subsidy law to now enlarge it. And then, if I may use a little bit of discretion and say something about the FCR, because I think the parallel is very interesting. Even in the case of the FCR, this new regulation by the EU on foreign subsidies, we are dealing with a sort of cross-border subsidization, although it is not the type of transnational subsidies that we are talking about specifically now. It is not what was under dispute in DS616 because it is not about the imports of goods. It is basically about foreign direct investment, largely. So it would be very interesting to analyze whether this is in line or not with the WTO agreement on subsidies, because the very first question is, once again, could a foreign subsidy amount to a subsidy under WTO subsidy rules? Or are we talking about something which is completely beyond the scope of WTO subsidy rules because it is not really a trade type of scenario or a possible type of trade distortion? I know this is the main argument put forward by the European Commission, suggesting we are fully aware of Article 32.1 of the WTO agreement, but this is completely different. It's a different animal. But I wanted to raise this point as well. But I think the parallel is very interesting because it is really addressing the same type of issues that we have. New wine in old bottles. We have these new types of subsidization, cross-border subsidization, which was not really prevalent in the 1980s, 1990s, and now we have to deal with that with the tools, the regular tools that we have.
Thank you, Luca. Very interesting comment. Winam?
Thanks, Gabriel. Perhaps I'm going to just use my two minutes just to raise some questions for us to think about and add to this panel. And hopefully those will be kind of creating some questions for us to think about this issue more broadly. I think the first issue we need to be thinking about is the rise of industry policies nowadays, and also the geopolitical competition among all big players, not only within their territory, but also overseas. So I'm thinking about the EU's Global Gateway initiative, which in a way that replicate many features of the Belt and Road Initiative. So how would that actually play out in terms of the reaction by other major stakeholders in relation to the subsidies or any financing that EU may actually provide for that kind of investment? So that's one of the things. I think in a world that industry policy and subsidies are on the rise, everyone can be a target. So and again, I want to emphasize the point. I don't think that developing countries should be the coyote in the crossfire of big players. I think we should leave developing countries to use capital, foreign capitals and technology so that the importing country and the subsidizing government can deal with their issues. And this can be there can be many different ways of resolving these issues. It does not have to be withdrawing the subsidy or canceling the subsidy that is provided to the developing countries. But it could be, so for example, the EU withdrawing concessions provided to the Chinese exports. So that kind of thing, or something that China may actually agree to as a mutually agreed solution. So I think the land violation claim provides at least an interim solution in this process. I think one of the participants raised the question of how difficult the multilateral negotiation would be, and we perhaps would not actually see the end of it. But I think in the interim, I think countries should start trying using non-violation claims.
Thank you. I'm very interested by your comment that with 26 of DSU, the old GATT requirements and conditions for non-violation, including no provision, does not exist anymore. But that's for a future discussion. Liz, 2 minutes, really 1 minute and a half, because I want to thank you.
Just to wrap up, to say that and pose a question back to all of us to think about: is the current WTO rules adequate to deal with anti-competitive behavior? We are trying to use the SCM as the tool that we have to deal with anti-competitive, but as we can, from the discussion, it may not be sufficient. So bearing the inability of the WTO to come up with something new, how do we then try and deal by countries who are facing anti-competitive behavior to deal with these sort of issues in the interim, so that there is, at the end of the day, it's not all about rules and laws. It's about your company's survival, jobs created for your citizens. So what else in the toolbook can we think about to help this anti-competitive behavior, and start to raise discussions maybe in smaller groups at the WTO as to how else can we look at anti-competitive? And don't forget to also look at the agreement on agriculture, which has a lot of provisions on subsidies.
Thank you. Thank you very much to all. We have exhausted the time. A very complex issue, but inherent to supply chain and globalization. An outstanding panel. And I say thank you to Ambassador Matus for having sort of hosted this conversation. And goodbye to everyone. Ambassador Matus?
No, just to say thanks to everybody. I am very impressed about the precision with the hour. So congratulations. This is not very often. Thanks to the participants, thanks to the speakers, and of course, thanks to this extremely able moderator as Gabriel. And keep in touch, because this is the third round. This is the third opportunity of tackle panel decisions and WTO issues. So probably in the future we will have more of this. And have a nice day or night, depends on where you are. Bye-bye.
Thank you to all panelists and participants.
Thank you. Bye.
Thanks, Gabriel.
Bye.
Bye.
Thank you.
Bye.